Today, I'll explore employee privacy in the workplace, focusing on the balance between legitimate business needs and individual rights. We'll examine three connected areas: workplace monitoring, policies governing personal conduct, and employee testing. The central question is where an employer's authority appropriately ends and where an employee's expectation of privacy begins. By looking at the legal, ethical, and practical dimensions of these issues, we can better understand how workplace decisions affect both organizational responsibilities and employee trust. This learning objective overview focuses on the boundaries between legitimate workplace oversight and employee privacy. We'll examine honesty and integrity tests, drug and alcohol testing, workplace romance policies, and communications monitoring. Employees retain meaningful privacy rights even within the workplace. The key is understanding when an employer's authority is justified and when a policy or practice crosses legal or ethical boundaries. These issues matter to both business leaders, who design and enforce workplace policies, and workers, who need to understand their rights and responsibilities. The foundation of workplace privacy is understanding that the Fourth Amendment generally limits government searches, not private employers. In the private sector, employer authority is broader, and employee privacy is shaped by several overlapping sources. Federal laws, such as the ECPA and ADA, establish baseline protections. State laws may provide stronger safeguards. Employment contracts and workplace policies can also expand or limit expectations. Finally, courts consider what privacy an employee could reasonably anticipate in the circumstances. So, privacy at work depends on both legal rules and workplace context. Employers may monitor business communications on company-owned systems, including email, internet use, and phone calls under the Electronic Communications Privacy Act, or ECPA, when employees have been notified. Transparency and a written policy are the key protections for the employer. Personal devices and accounts generally receive stronger protection, while employees using personal email on company networks may have mixed protection. Phone recording also requires special attention because some states require consent from both parties. The practical takeaway is to disclose monitoring clearly and document the policy in advance. Monitoring practices exist on a spectrum, from relatively limited observation to more intrusive forms of employee monitoring. As an employer moves further along that spectrum, the need for clear written policies, legal review, and a documented business justification becomes increasingly important. Transparency is the single most important safeguard. Employees should understand what is being monitored, why it is necessary, and how the information will be used. That clarity helps establish trust and provides a stronger foundation for responsible monitoring practices. Workplace romance can create genuine legal and operational risks, especially when a relationship involves a supervisor and a subordinate. The central concern is the power imbalance, which can lead to harassment claims, favoritism, conflict of interest, and potential liability. Some employers use love contracts or consensual relationship agreements to document that the relationship is voluntary and that both employees understand the harassment policy. But employer authority has limits. Blanket bans may conflict with state lifestyle discrimination laws, so policies should be narrowly tailored, consistently enforced, and clearly communicated. This slide outlines 4 situations in which drug and alcohol testing may be justified. Pre-employment testing is legal in most states, but employers must apply it consistently to all candidates for the same role. Testing may also follow reasonable suspicion when observable behavior or other evidence suggests impairment. After a workplace accident, testing is commonly used to determine whether substance use contributed to the incident. Finally, random testing is permitted in certain safety-sensitive industries, including transportation, nuclear, and defense, under federal law. Drug testing policies must account for the interaction between federal requirements and state-specific rules. Federal law mandates testing in regulated industries, while some states restrict random testing or require rehabilitation before termination. Medical marijuana adds another layer. Even where marijuana is legal, employers in most states may prohibit use and act on a positive test. The ADA protects people recovering from addiction, but not current illegal drug users, and alcohol dependency may qualify as a disability in some situations. Because this area changes quickly, always verify current state law before implementing a policy. This slide covers honesty and integrity testing under the Employee Polygraph Protection Act of 1988. In most cases, the EPPA prohibits private employers from using lie detector tests for pre-employment screening or random testing of current employees. There are limited exceptions, including federal, state, and local government employers, certain security and pharmaceutical companies, and investigations involving specific economic losses. Employers that violate the law may face civil penalties of up to $10,000 per violation, and employees may also have the right to sue. With polygraphs largely banned, employers often turn to written integrity tests as a legal alternative. These psychological assessments examine attitudes toward theft, drug use, workplace violence, and broader conscientiousness, with the goal of predicting reliability and counterproductive behavior before hiring. Their legal status does not eliminate the need for caution. Under federal law, these tests are generally lawful, but they must not create disparate impact against protected classes under Title VII. There are also ethical concerns because their validity remains debated, and honest, straightforward answers may sometimes disadvantage applicants rather than reveal genuine dishonesty. Effective workplace policy is not about maximum control. It's about proportionality, transparency, and consistency. Start with a legitimate business need, then choose the least intrusive approach. Communicate expectations clearly, enforce them equally, document procedures, and review compliance regularly, especially as marijuana and data privacy laws continue to evolve.